Well, good evening, everyone. I'm Dean Anne Bobinski from the Emory School of Law, and it's my great pleasure to welcome you all to the 7th Annual Atlanta International Arbitration Society Lecture. We are getting all the benefits of a hybrid session this evening, where some of us have had the opportunity to enjoy fine food and beverages and sharing conversations in person, and others who are not able to attend in person are able to join us online, including our distinguished speaker this evening. I want to thank Brent Klinkstale, president of AtlAS, for allowing us to partner with you all this evening to hold this special event. I've been mentioning to anybody I can, I'm so excited about it. You are our first outside group event since the pandemic began. Yes. We've started to have some internal events, accepted applicant days and things like that, but it's just so exciting to be able to welcome leaders in the profession and in the world to the law school. And we're delighted to have the opportunity to partner with you as you carry out your important work this evening. And Brent, I want to thank you personally for your leadership in the event and for working with our team to make this event possible. I also want to extend welcome to Mr. Sternford Moyo, president of the International Bar Association, who is just so esteemed and well regarded. And we're delighted to have him coming to us via Zoom from Zimbabwe this evening, where I'm told that it's after midnight. And so he looked very alert when I saw him just a moment ago, and another tribute to him that he's able to maintain that alertness at this hour. And his presence and the content of the lecture really reflect all that's important about the AtlAS organization and its global breadth and reach of the people who are involved in the organization and the important work that each of you are carrying out in your professional lives. I also have to offer a special welcome to Emory Law class of '68 graduate Ben Greer. And we're thrilled that Ben is going to be recognized this evening, that his leadership and practice and his service are being recognized by his peers, and that leadership and commitment reflect the very best of what we hope for Emory Law graduates, and allow him to be an inspiration for current students and other law school graduates. So just very pleased to have that as part of this evening's celebrations. And I also finally want to thank our professor, Michael Groyd, for serving as a moderator for the question and answer session tonight. Michael Groyd is an expert in many areas of law, a wise commentator, prolific author, and one of his areas of expertise is alternative dispute resolution. And we were delighted by that sort of connection that allowed him to be an able moderator for this evening. So with all of those remarks, and my warm welcome to each of you here and online, I will turn to Brent Klinkstale to lead the next section of the program. Thank you very much.
Podium's a little short for me. Thank you, Dean Bobinski. And welcome to the 7th Annual AtlAS Lecture. The poet writes, the law. But the law is just words, but the wind is just air, but the ocean is just water, but the mountain is just rock, but the forest is just trees, but the universe is just stars, but the law is just words. Martin Luther King said, a genuine leader is not a searcher for consensus, but a molder of consensus. It is with great honor as president of AtlAS that I am here with you to share this tribute to an exceptional lawyer leader, Ben Greer. Ben's former law partner, Randall Allen, said, as founder of Alston Bird's international practice, Ben led a practice that wrapped itself around the globe. As the chair of Lex Mundi, and now chair emeritus, Ben led the world's largest alliance of independent law firms, 150 law firms in 125 countries, and forged bridges between international legal practitioners and cultures worldwide. As founder and chair of Georgia's State Bar International Trade and Legal Services Committee, Ben steered Georgia's bar to the most progressive regulatory regime for foreign lawyer practice in the United States. He made it possible for non-US advocates and arbitrators to participate in international arbitrations seated in Georgia, propelling Atlanta as an international arbitral seat. As chair of the Japan American Society of Georgia, Ben connected cultures, making Georgia, Atlanta, and the Southeast more inclusive, dynamic, and progressive. As Secretary General of the International Bar Association and through other offices in the IBA, he molded consensus to facilitate the balance between regulation and competition, a competent and independent international legal profession, economic development worldwide, and a robust legal framework to shape the rule of law. And as AtlAS president, he sustained the momentum that ensures Atlanta's prominence as an international gateway and AtlAS as a pillar of that gateway. And he started this lecture series, of which we continue and we celebrate this evening. I give you the architect of the words, the air, the water, the rock, the trees, and the stars that hold AtlAS in this international legal universe, and that continues to mold the consensus of cultural connectivity and education. He is the subject and the husband of Linda Greer, and she is his verb. They both are good friends of our speaker, Sternford Moyo. Ben, would you share some words with us?
Wow. Thank you so much for those kind words, Brent. I really appreciate it. And Dean Bobinski, thank you for hosting the lecture. AtlAS has been such a great part of my professional life and a great story that it illustrates the Atlanta community and our community here in this region. I should be honoring you. And thank you very much for your kind words. The pandemic has given us a lot of opportunity to go through our storerooms and rummage through what we've saved over the years, and given us a chance to reflect on how our lives have turned out. What struck me during that process was how much the journey was caused, my journey was caused not by design, but by a combination of happenstance, some things over which I had no control, bum luck, and some determination on my part. And to illustrate, the first thing I had no control over was the building of the Berlin Wall, which caused the cancellation for OTC students for a period of time of all the deferments for graduate students, for graduate study. So I was not able to go to law school right after my graduation from university. So I had to spend 2+ years in Germany, and I discovered, that's where I discovered my passion for things international. I'd never been much of anywhere outside of East Tennessee, and it was a liberating experience. Then after I left the Army, I was determined, inspired by my international travel, to go into the Foreign Services, and I was in the middle of that. And I met Linda, and she agreed to marry me. So we went back to plan A, which was to go to law school, and I went to Emory. And I picked Emory because it was in Atlanta, the beacon of tolerance and the leading city in our region. And I've never regretted that choice, but during recruiting season of my year, I discovered that the 3 firms I was interested in were not interested in me. And so I went to New York to try to get some corporate securities and international experience. And so while we were in New York, we were getting ready to come back to Atlanta, which had been the plan. And they called me in. And they said, how would you like to go to Paris? We're opening an office in Paris. And I said, well, that sounds like a good idea. And so I went home and talked to Linda about that. And she thought that was a very good idea, having taught French at Lovett School while I was in law school here. And so we spent 2 years in Paris. And then some years later, after we got back to Atlanta, and after I had sort of kept my toe in the international water, but had built up really mainly a corporate securities practice, Alston Bird called, and that was the luckiest day of my professional life. And since then, whatever I've done nearly in the last 40 years, I really owe to the partners of Alston and Bird, especially Neil Williams and Ben Johnson, whose trust and support I hope they feel I earned. So I should add that relationships with clients also helped. You can't do this without having some paying clients with whom I still have some relationships. But what you're looking at here is one of the luckiest people who's ever lived. I pretty much accomplished what I set out to do in my career, but the path took many different directions leading to where we are today. And we're not finished, by the way. But if there are any students here, I'm not sure there are, but if there were, my advice would be to work hard and be the best lawyer you can be and hold on to your dreams. And you never know when the opportunity will come calling. And when it does, to quote Yogi Berra, when you see a fork in the road, take it. Now, let me just say one other thing. Doing what I did over many, many years convinced me that the key to economic development and the maintenance of human rights in a civilized society is the rule of law. And it consists of laws that make sense and are consistent with generally accepted norms, an independent judiciary free of political influence, and a strong and independent legal profession. And our speaker today, I don't want to steal Ajua's thunder, but our speaker today is a true champion of the legal profession, and I very much look forward to hearing what he has to say. And I yield now to Ajua Seymour, who will formally introduce our speaker. Thank you very much.
Thank you, Ben. Thank you, Ben. It is my honor to present a former bar leader in Zimbabwe and in Southern Africa, and a corporate leader in mining, manufacturing, financial services, and leadership development. And I hope we can still see him when he's up there. But hailing from Zimbabwe tonight is Sternford Moyo. Let me make sure this comes down. Okay, so hailing from tonight is Sternford Moyo. He is the current president of the International Bar Association, and he is the first IBA president of African descent in the history of the 75-year-old organization. His dedication to the IBA and the legal profession has been long tenured, where he has held many numerous roles, many senior IBA roles, including council member, management board member, and the IBA's Deputy Secretary General for Southern Africa. He has also held leadership positions with the IBA's Human Rights Institute and the African Regional Forum, as well as the IBA's established entities such as the Southern Africa Litigation Center and Eyewitness to Atrocities, and the Task Force on Illicit Financial Flows, Poverty, and Human Rights. And he is a former president of both the Law Society of Zimbabwe and Southern African Development Community Lawyers Association. And in the corporate role, in addition to his leadership in the global legal profession, he is widely regarded as one of the leading corporate and commercial lawyers in Southern Africa. He serves as chairman and senior partner of the law firm Scanlon and Holderness. And as a senior partner at the large corporate law firm, he specializes in mining, corporate and commercial law. He has advised financial institutions and loan underwriters in most of the large infrastructure projects that have taken place in post-independent Zimbabwe in the areas of forestry, energy, telecommunications. And he's also provided advice on navigating Zimbabwe's empowerment laws and has been actively involved in most of the empowerment transactions, which have been publicized so far. And he is a former chairman of Stanbic Bank Zimbabwe Limited, a leading commercial bank in Zimbabwe, Schweppes Zimbabwe Limited, and the Zimbabwe Revenue Authority, and has served as a director for several corporations as well, such as the Alpha Media Holdings Limited, one of the largest and most diversified media companies. During the early part of his career, he taught corporate and commercial law, and in corporate and constitutional law. And in 1990, Mr. Moyo was selected by the United States Information Services to participate in a program to familiarize young African leaders with the American legal system and its background. About his role as IBA president, Mr. Moyo has expressed a commitment to working towards, and this is in his own words, deepening the fulfillment of the objectives of the IBA and increasing diversity, eliminating all forms of discrimination in the practice of law and the administration of justice. Ladies and gentlemen, it is my honor to present tonight Sternford Moyo, followed by a Q&A that will be moderated by Emory's very own Professor Michael Groyd.
Thank you very much, Chair, for those very kind words. President of the Atlanta International Arbitration Society, Dean of the School of Law at Emory, distinguished guests, ladies and gentlemen. Let me start by expressing my deep gratitude and appreciation for the opportunity you gave me to participate in your 7th annual lecture. It really gives me great pleasure to be here. Atlanta is a city I've always admired. In fact, during my long visit to the United States, it is one of those cities I visited. I'm also very pleased to be participating in your lecture. I see that your society is committed to diversity. I've already seen evidence of diversity, from the little interaction I have had with your society. So I'm really pleased to be here. I've been asked to speak on the importance of international dispute resolution mechanisms in international agreements. A very important topic indeed. I'll start straight away. The very first importance of international dispute resolution mechanisms in international agreements is the elimination of costly and protracted disputes around issues such as jurisdiction and choice of law. Where an international agreement takes place, there will be connecting factors, connecting the parties to different countries. And depending on the preponderance of connecting factors, and also depending on the residence of the respondents, the jurisdiction can be any of the countries where the parties come from. In providing for international dispute resolution mechanisms in the contract, one avoids a situation where arguments will arise as to which country has jurisdiction, which courts have jurisdiction over the matter. One avoids arguments as to the choice of law, the law applicable to the dispute between the parties. Very often, disputes around that tend to be complicated. These are disputes arising from conflict of laws, disputes arising from private international law, a very difficult subjects that most of you will remember from your school days. So those disputes can actually take a life of their own. They can take months or years to resolve. They can cost the parties huge amounts of money to resolve. They can also really drain the energy out of the parties and divert the parties from the real issues, from the real dispute, or from the reason why they came together in the first place. So that is the very first factor of importance as to why it is necessary to have international dispute resolution mechanisms when crafting international commercial contracts. The second one is one I'm going to spend a little more time on. This is neutrality. Justice is rooted in the confidence of the litigants. It is also rooted in the independence and impartiality of the adjudicator, the decision maker. Where there is no confidence in the independence and impartiality of the decision maker, it stands to reason that justice is not sufficiently rooted in a dispute of that nature. And without confidence, without justice being rooted, it is unlikely that the parties will be happy with the outcome of any dispute resolution that may take place. It is also unlikely that the dispute resolution mechanism will achieve the desired objective. The objective, of course, is to resolve the disputes, to allow the parties to continue with their lives, to allow the parties to continue with their business. And as long as the dispute detains them, it becomes very difficult to focus their energies on what it is that they will have decided to pursue in their lives. So that is why neutrality of the arbitrator, that is why neutrality of the person to decide the dispute is so important. The independence and impartiality of the person who decides the matter is extremely important. Where there has been no mechanism in the contract between the parties, what it means is that one of the courts will have to deal with the matter, one of the national courts. And obviously the party who does not belong to that country or party who is a foreigner in that country will feel that he or she will not have confidence in the dispute resolution that is taking place. And as I have mentioned, without confidence on the part of the litigants, justice is not sufficiently rooted. Prospects of resolution of the dispute become limited. So where there is neutrality, in the sense that the parties have been able to choose an institution such as the Atlanta International Arbitration Society, for instance, or any other dispute resolution center, the prospects of the parties having confidence in the outcome, the prospects of the arbitrator being neutral become higher. I have started with this element of neutrality because it is one of the highly contested terrains as far as arbitration is concerned, especially in international dispute resolution. In Africa and South America, many lawyers, government officials have criticized international arbitration, challenging this very aspect of neutrality. Indeed, one commentator observed that the feeling persists among African officials, lawyers and business people, that international arbitration is essentially a distant and alien system located in a foreign country, administered by foreign experts, applying foreign law with little appreciation of the conditions in African countries. That's part of the criticism that we have had. This criticism is largely unjustified, as I will demonstrate when dealing with some of the examples that I have. But it does exist, and it is necessary for us to deal with it so that we may appreciate as to where it is that it is coming from. Many of you will remember that in 2012, South Africa withdrew from the bilateral investment agreement with Belgium and Luxembourg as part of the first series of withdrawals from such agreements on the basis that it could not have sufficient confidence in international arbitration. It cited at the time that when it entered into these agreements, it was a newly independent state, it just achieved democracy, and did not fully appreciate the consequences of entering into these agreements. Many of you will remember also that in 2007, Bolivia exited the International Center for Settlement of Investment Disputes. And in 2009, Ecuador exited the center. In 2012, Venezuela exited the center as well. Obviously, these countries were exiting the center because they had no confidence in international arbitration. They felt that international arbitration tended to favor foreign business interests or the investors investing in their countries. Yet their awards do not show that at all, because a substantial number of disputes, especially around investment agreements, have been resolved in favor of the host countries and against the investors. For an example, in the case of Donegal and Zambia, a 2005 case, Zambia was in breach of a US 15 million credit facility. And it was taken to international arbitration. At the time Zambia was taken to arbitration, the amount had rocketed to 55 million. Zambia raised the defense that the interest charge amounted to an illegal penalty. The award reduced the amount to 15 million in favor of Zambia, in other words. In the case of Bywater Gulf, Tanzania, and the Republic of Tanzania, a 2007 case, Tanzania was in breach of its bilateral investment agreement, and it was taken to arbitration. The claimants were claiming 20 million in that case. The arbitrators were not satisfied as to the causal link between the loss that Bywater had suffered and the breach that had been committed by Tanzania. And although they found that Tanzania was indeed in breach, they declined to award any damages to Bywater in that case. A number of you will be aware of the Saline case, which has given rise to the Saline rule. This is Saline and another versus the Kingdom of Morocco, a 2001 case. It was decided in that matter that to qualify as an investment for the purposes of bilateral investment protection agreement, the investment had to contribute to development. Again, that test as to the to what amounts to an investment agreement is a test in favor of the host countries and not a test favorable to investors at all. A number of you will be aware of the case of World Duty Free Company versus the Republic of Kenya, a 2006 case, where Kenya had violated an international investment agreement. It was taken to arbitration. Kenya pleaded corruption, pointing out that the agreement in question had been facilitated by payment of a bribe of $2 million United States dollars. The World Duty Free company pointed out that it had indeed given a gift of $2 million to President Moyo, who was the president of Kenya at the time the agreement was entered into. The arbitration was concluded in favor of Kenya, in that the arbitrators found that that inducement was a corrupt inducement and declined to make an award in favor of the duty-free company. Now, you can see from just those few cases that I have cited that the criticism that international arbitration tends to take place in foreign countries, applies foreign law, favors foreign companies, and does not have an appreciation of what Africans and South Americans are trying to establish in their countries is largely unjustified. What the critics are in fact trying to say is that they expect international arbitration to apply some exceptions, exceptions which are not contained in the agreements that appear before the arbitrators. Now, that clearly is not a fair and equitable way of making awards in arbitration. Why I say that the critics expect this is that you'll find that when South Africa withdrew from the International Center for Settlement of Investment Disputes, it had been taken to arbitration in the Pero Foresti case versus South Africa. What South Africa had done was to withdraw all ownership of minerals in the ground, declaring that all minerals in the ground belong to the state, and all that a miner can obtain are extraction rights, in other words, an extraction license, as opposed to ownership of the minerals themselves. You only own the mineral after you've mined it and brought it onto the ground, taken it out of the ground, in other words. That's the stage at which you become an owner. It also abolished the old concept of minerals belonging to the owner of the land, under the principle, he who owns the land owns it from hell to heaven. That was no longer applicable as far as minerals are concerned. South Africa said it was doing this in order to achieve transformation and achieve a break from the dark apartheid past that it had suffered. It wanted to achieve some form of affirmative action, ensure that there is equitable ownership of mining rights, minerals in South Africa, because many of the minerals were actually being mined by large corporations, some of them not South African corporations. And this is what South Africa was trying to correct at the time. Very few Blacks were involved in any form of meaningful mining in South Africa. So in order to correct that legacy of apartheid, South Africa decided to introduce that legislation. But the agreements that it entered into did not take into account the fact that it was going to introduce this program of transformation. That is why it found itself in difficulties. In that case, the arbitrator actually allowed intervention by interested human rights groups to argue in support of South Africa's position on the matter. The dispute was settled amicably between the investor and South Africa. In the case of Zimbabwe also illustrates that, the host states tend to have expectations which are not written into the bilateral agreements, in the international agreements. And they expect the arbitrators to take the expectations into account, notwithstanding the fact that they will not have negotiated them into their agreements. Zimbabwe decided to embark on a fast-track land redistribution program, which many of you will be aware of. It became notorious. It was associated with gross violations of human rights, violations of the rule of law, and it was taken to arbitration in the case of Border Timbers, which was one of the owners of forestry in the Eastern Highlands. Some chiefs in the Eastern Highlands, about 4 of them, applied to join the litigation, supported by the European Center for Constitutional and Human Rights. They were unable to join the litigation. In that matter, the arbitrators ruled that there was no basis on which they could seek intervention in the dispute, much to the disappointment of Zimbabwe. Ultimately, a ruling was made against Zimbabwe in that matter. Zimbabwe thought that obviously was disappointed that the arbitrator did not take into account the fact that it was trying to establish an equitable system of land ownership and utilization. But that intention was not written into the agreements that the country had entered into, the commercial agreement that the country had entered into, in which it promised to protect investments. So what really has been missing in most cases is some kind of a balance between protection of investors and the protection of the developmental rights of the communities where the investment takes place. The countries in South America and some of the countries in Africa have tended to expect arbitration to bring out this balance, despite the fact that the balance was not really written into the agreements that had been entered into. And it is for that reason that international arbitration has been unfairly criticized in Africa and in South America. There is no way that the arbitrations or the arbitration centers could have taken into account in interpreting agreements factors which were not contained in the agreements themselves. Part of the problem, of course, is that there is some kind of an imbalance of power when these investment agreements are negotiated. The countries are trying to attract foreign investment. They feel that without those agreements, they will not be able to attract foreign investments. And in their zeal to attract foreign investment, they do not put on the table what their expectations are. They do not put on the table what their requirements are. They do not outline their developmental programs so that the agreement they enter into take into account those programs. It is for that reason that international arbitration has been criticized as it has been. Societies such as yours can play an important role in ensuring that there is transfer of expertise into places like South America, into places like Africa, so that African lawyers can be able to play a meaningful role in advising governments when they enter into these agreements, can also be able to play a meaningful role in explaining where the arbitration rulings come from, and in explaining that indeed there is no evidence of bias, there is no evidence of application of foreign law without taking into account the practical realities on the grounds in Africa, South America, and other places that try to attract investments. So I've taken some time on that because, as I indicated, the issue of neutrality is extremely important in international arbitration. It is an important factor that should encourage parties to enter into dispute resolution mechanisms, because they will be able to choose a center which is free from any biases, which is free from any association with one of the parties, because without that, the dispute will be resolved in one of the courts of one of the nationals involved in the dispute. And as I indicated earlier on, that is against the root of justice, which is rooted in confidence by the litigants, rooted in the independence and in impartiality of the decision maker. The third factor of importance that I would like to raise is that of a selection opportunity. When you enter into dispute resolution mechanism in your contract, you actually have an opportunity of selecting the most suited person to deal with the dispute. When the dispute is dealt with in the law courts, most judge presidents will allocate the dispute to the duty judge to deal with. That duty judge may not be a commercial lawyer or may not be sufficiently skilled to deal with the dispute, may not quite understand what the parties are trying to achieve or what the dispute is all about. And as a result, it's highly unlikely that the parties will receive the outcome they expect. It's highly unlikely that either of the parties comes out of court happy because judges are judges. They are not necessarily commercial lawyers. They may be very strong lawyers in many respects, but these commercial disputes tend to be complex, and they require people with a huge amount of commercial experience to deal with. A further factor of importance as far as dispute resolution mechanisms are concerned is that you actually take away the dispute from the adversarial environment, which is not friendly to business. The hearing takes place in an open court. It is open to the media. There is extensive publicity. It becomes very difficult for the parties to do business together after that. In other words, it becomes very difficult to actually resolve the dispute arising between the parties because of the glare of publicity and the hostility associated with the adversarial system of litigation. That is absent from arbitration. Because arbitration takes place, it's in an environment where there's confidentiality, privacy is protected, the private interests of the parties are protected, the parties are able to conduct their dispute in a friendly manner and are able to do business together afterwards. Doesn't always happen because lawyers do take part in these arbitrations, and some lawyers find it very difficult to get out of the litigious mode, get out of the courtroom battles that they normally participate in disputes in the national courts. So you find that sometimes an arbitration can actually be even more complicated than a court battle. You find there's discovery, there's inspection, there are motions that take place before the arbitrators. The advantage with international dispute resolution centers such as yours is that they've got a pool of skilled arbitrators who are able to bring to the arbitration the right atmosphere. In other words, move away from the court, move away from the court spirit, move away from the court motions and battles, and try to simplify the proceedings and ensure that the focus is on resolving the dispute in a manner that achieves a win-win for the parties, as opposed to the adversarial system of litigation that really tries to produce one winner, but ends up producing no winner at all. The next factor of importance as far as international dispute resolution mechanism is finality. There is no appeal against an arbitral award. Because of that, one achieves finality. It is, of course, a double-edged sword in the sense that to err is human. When error is made, which may be a glaring error, it becomes difficult to correct it through the mechanism of appeal. The right of appeal is a very important right. But, in arbitration, we feel that finality is more important, in fact, because it's more important to resolve the dispute and allow the parties to carry on with the business of running companies as opposed to spending time in the courts. There is, of course, a mitigant in the sense that, where there is gross irregularity or the decision is contrary to public policy, under Article 34 of the UNICITRAL law, which is now widely considered to be the model law, it is in fact the UN model law on arbitration. It is possible to have the award set aside. That is not without its own problems, because you're going back to the courts, the very courts that you wanted to avoid. And furthermore, if you look at the wording of Article 34, it says the award, one of the grounds on which it can be set aside is that the award is contrary to public policy. Now, it is not that the making of the award is contrary to public policy. In other words, it addresses the substance of the award itself. That has resulted in a number of lawyers trying to bring back the right of appeal on the basis that, if it is glaringly wrong, it can't be consistent with public policy to allow it to stand. Fortunately, in most jurisdictions, the courts have been friendly towards arbitration and have interpreted that clause to mean that it's only really in circumstances where there is some gross irregularity that it will set aside an arbitral award. It will not set aside an award merely because it could have come up with a different conclusion to the dispute. That has been the case in many countries. So there is that element that, finality is definitely a factor of importance as far as dispute resolution is concerned, but it is not without difficulties because of the right to set aside the award, which has tended to bring arbitration back to the courts. There is a further factor of importance, which is enforcement. Most countries, many of the important jurisdictions are party to the New York Convention on Reciprocal Enforcement of Arbitration Awards. And that has tended to make enforcement of these awards a lot easier than trying to enforce awards from national courts. In many jurisdictions, the state enjoys immunity from execution, even after a judgment. So it becomes problematic trying to enforce a judgment by the national courts. Whereas, as we have seen, it is relatively easier to enforce arbitral awards because of the international conventions that have been entered into around that, especially the New York Convention on reciprocal enforcement of arbitral awards. However, notwithstanding that, you still have cases such as the Bernardus case or the Border Timbers case that I referred to, which arose in 2000 and 2001 and involved a number of commercial farmers in Zimbabwe. To date, those farmers have not received compensation despite the awards that have been made. There have been attempts to stay enforcement of the awards, pending some motions raised by the government of Zimbabwe. All sorts of defenses, such as necessity, have been raised. Delays can take place even where arbitration awards are given, but they tend to be a lot better than the type of delays you encounter where the state is unwilling to obey a judgment from its own national courts, and there is no system of enforcement that you can resort to because of the state immunity from execution. Now, because arbitration ensures that you get an independent and impartial adjudicator, as opposed to an adjudicator that lacks neutrality, it is inherently supportive of the rule of law. It does work as a mechanism for checks and balances against excessive executive power, excessive legislative power. And because of that, it really is important in ensuring a climate of legality. It is important in ensuring that the right thing is done. Climate of legality is really one of the most important elements of the rule of law. The ability to impose checks and balances on executive powers is also an important element of the rule of law. So international commercial arbitration is, because of those factors, is actually one of the mechanisms promotive of observance of the rule of law. It is important to the administration of justice. In fact, I have argued in some forum that we should not continue to refer to things such as arbitration, mediation, conciliation as alternative dispute resolution mechanisms. We should rather refer to them as additional dispute resolution mechanisms. Thank you. That is all I have to say. Thank you very much for inviting me to speak to you.
I'm Michael Groyd. I teach arbitration law here at Emory Law School, as well as in the Center for the Study of Law and Religion, and it's my pleasure to moderate questions and answers. First of all, does anybody in the audience want to ask a question of our lecturer? Please, there's a microphone over there, and it's an easy opportunity to ask a question. And if not, I will follow up with the first question, which is, how important is privacy in these international arbitrations? To lay out a question for our speaker, is privacy as important in these kinds of international commercial arbitrations as they are, for example, in American family arbitrations, where people routinely go for arbitration due to privacy concerns?
It does not have the same level of importance. As you could see, I was able to refer to some arbitral awards because there has been publicity following those awards. So it's definitely not at the same level, but you do not have the typical adversarial hostility that you will get in litigation. You do not get the same level of publicity that you would get in conventional litigation. In other words, litigation through the courts.
Thank you. Please.
Mr. Moyo, thank you for appearing before us today and sharing your knowledge about dispute resolution. My question goes to your first major point, and that has to do with confidence in arbitration as a dispute resolution mechanism. And my question particularly addresses the legacy of colonialism, particularly in Africa. And I wonder, in the 60-some years that have of evolution since the great wave of independence between 1957 and 1964 in Africa, starting with the Ghana and moving through, whether or not, in your opinion, there exists a legacy amongst particularly the practitioners in the field that tends to, or that might tend to take away any or limit any form of independence or neutrality of both the advocates and the neutrals in the field as a result of a colonial past. And by a colonial past, I refer to particularly the European powers who originally colonized Africa, particularly England and France, but also Portugal. And I'm wondering if, as a result of that history, whether the legacy of that has been swept aside in the fullness of time, and where the ties that were once renounced have been fully shed.
Well,
I'm sorry for the complicated question.
No. That's a very important question, and it is very relevant. I think you will see when I dealt with the issue of neutrality or independence and impartiality of arbitrators, I did raise, the common perceptions in Africa and South America that this type of international arbitration cannot be neutral, cannot be impartial, cannot result in arbitrators being independent. But I tried to take some time on it because I think that with education and more understanding of how the legal systems work, with education and greater understanding of the importance of neutrality, the importance of impartiality, the importance of independence, you'll find that judicial officers in Africa, judicial officers in other parts of the world that were subject to colonialism, such as Asia, are robustly independent. That is why I concluded that what is really needed as far as international arbitration is greater education, greater appreciation, a greater sharing, transfer of knowledge, transfer of skills will be able to resolve some of the perception problems that you find in that area. The perceptions do exist. Yes, the fear of bias does exist. That is, in fact, the reason why it is important for the parties to be able to choose the arbitrators who may be from different parts of the world, not necessarily subject to the national bias one would expect to find in a country where they litigate in the courts. It actually speaks to the importance of international arbitration as opposed to litigating in the national courts.
Please.
Yes, hello, Mr. Moyo. My name is Christoph Siefert. I'm a German lawyer, but I'm also spending a lot of time in Georgia if I can. I have a question to you combining arbitration and your role with the IBA as the president of the IBA. The IBA rules on the taking of evidence are very important to us and are a good compromise between civil and common law. My question to you is, do you have any plans to expand on this and to, for example, introduce some other IBA rules, particularly in the area of arbitration? Thank you.
You know, the IBA is a living organization. It's a learning organization. It's an organization in which work is taking place all the time. As I speak to you right now, there's something like 150 projects within the IBA, some of them around dispute resolution. So yes, the IBA does not stand still at all. The IBA is constantly trying to push the frontiers of knowledge, constantly trying to improve on what is available. IBA never comes to a position where it feels that everything that can be learned in any aspect of the law has been learned. We're constantly pushing the frontiers of knowledge. We're constantly trying to find new solutions. We're constantly encouraging committees and members to work on new projects, to find better ways of doing things. Yes. So I hope you are a member of International Bar Association and that you are participating in trying to make sure that, this area of dispute resolution continues to enjoy refinement and improvement.
Please.
Okay, good evening. Thank you again, Mr. Moyo. I am so empowered and inspired by your presentation and your expertise in this field. Having worked with ICSID, the International Center for Settlement of Investment Disputes, before starting my own practice, I always observed how the seat of arbitration was either in DC or in Paris. That's what the parties would typically choose as to where they would have their arbitration proceedings. And I always wondered if there were centers already established in Africa that could be used. And if so, I would like to know what your recommendations are for the establishment of arbitration centers in Africa and also for the promotion of the use of those centers. Thank you.
Give us your name as well. I didn't.
Donna Robinson. Thank you.
Pleasure, Donna.
Thank you.
Thank you very much for that important question. Certainly, establishment of effective arbitration centers in Africa and other parts of the world will take away this charge that it is a foreign process administered by foreign lawyers, administering foreign law without appreciation of the realities in Africa, Asia, and other parts of the world. Yes, arbitration centers are being established. I think you may be aware that Southern Africa is establishing an arbitration center which promises to be very strong. Zambia established an arbitration center, and Zimbabwe has an arbitration center. Most of the countries in Africa are establishing arbitration centers, but they can benefit enormously from skills transfer from societies such as yours, the Atlanta Arbitration Society, In that regard, I was really pleased to see my good friend Ben Greer here in Zimbabwe, trying to empower local lawyers with commercial law knowledge. He and other people have been to our country, have been to other parts of the world, trying to ensure that the skills transfer. That is the kind of activity that will strengthen those arbitration centers.
One last question, if anybody wants to ask, please. And if there's a question that can be posed by chat by any of the people who are online, I'd welcome to read it as well.
Hello, my name is Rebecca Kolb, and I'm a practitioner at a litigation boutique in Atlanta. I was wondering, a lot of what you were discussing left me with the impression that you're seeing a lot of investor state arbitrations. Is there a fair presence of commercial arbitration? And if so, are you seeing it largely with countries outside of Africa, or do you see inter-African arbitration, commercial arbitrations?
There is a substantial amount of commercial arbitration. It is relatively free from the type of controversy surrounding investment dispute resolution. There is a lot, and the major problems as far as that is concerned has been that where the parties choose a center, for instance, far away from the African state, if it is an African state involved, because of shortage of foreign currency, the cost involved in pursuing arbitration proceedings, I have found that some of the disputes really do not receive the type of attention they ought to receive. There was a glass factory in Zimbabwe that was a joint venture between a public company and a foreign private company. Things did not go well. The arbitration was almost impossible because of the incapacity of the public company to participate in the arbitration proceedings. The costs were prohibitive because they needed to travel to where the arbitration was going to take place. They needed to accommodate their witnesses there, and it proved really difficult. But there is a lot that is taking place, and that is taking place successfully. It is relatively free from controversy. I cited the example of investment arbitration because that has tended to have more controversy around it. And as I pointed out, that controversy is really a result of a failure to appreciate the fact that arbitrators cannot write into the arbitration agreements what is not there. What is needed to be done is to improve the negotiation skills of the people that craft these agreements and ensure that the developmental expectations of the countries are incorporated into those investment agreements.
Thank you, Mr. Moyo, very much for your lecture. We all very much appreciated it. And please.
Well, thank you all. Thank you, Professor Groyd, for moderating this discussion. And thank you very much, Sternford Moyo, for appearing today. I know that it's well after midnight where you are. So we really appreciate you speaking to us today. It's an honor for the Atlanta International Arbitration Society to have such an esteemed speaker. And I would also like to say that just at this particular moment in the world affairs, to have the leader of the International Bar Association, which has been around since 1947, but whose mission is to promote the rule of law and the protection of human rights. It's very important to hear from the IBA, and I think that all of us have a duty in this room to participate in part of that mission. So thank you again for all that you are doing and for all that the IBA is doing. I would also like to thank the Emory Law School. Dean Bobinski, thank you very much for hosting this event. It's fantastic to be here. I think that the last time we were here, maybe 3 years ago for our fourth annual lecture. We're glad to be back in person. And I think that for those of you who are listening, you know how important it is to AtlAS to have our relationship with all of the Atlanta regional law schools, Emory, University of Georgia, Georgia State, Mercer. I think that it's critical that we build on these relationships, and I'm very excited that after the pandemic that we'll be able to continue to have more events like this and to build our relationships with the students who really are the future of the profession and the future of AtlAS. I do want to talk about a couple of upcoming events. I'm not yet the president of AtlAS, so I've got 3 more days left, but a couple upcoming events. So Brent wanted me to give these announcements tonight and not him. So here goes. We have an upcoming plenary meeting, and some of you may have heard that the plenary on May 12th, we had planned an event on disputes arising out of the Russia-Ukraine conflict. We still plan to have that event, but one of our speakers just informed me this afternoon that he's been ordered to appear for a jury trial and will not be able to attend that event. So we're going to move that date by a week or 2, or maybe into June. I'm not sure exactly, but we will have some programming and an announcement on what we're going to do for our May plenary event. So watch your emails for that. We also are going to have some more social events like this. I thought it was great to see everybody in the room. There also has been a lot of interest from some of our younger practitioners, and younger practitioners, technically I've aged out of that because I'm over 45 now, but we are going to have some young practitioner events, some happy hours, social events, so that we can all get back together like we used to do before the pandemic. I'm excited about that. I think that the conference, I think people have heard that the conference, we have a date, which is the conference this year in the fall will be September 12th through the 14th, with GAR Live will be on September 13th, and King & Spalding has graciously agreed to host that event. We're excited about that. We will also have a Young Arbitrators Forum. We will have the AtlAS Forum and whole host of events. So we hope that everybody will sign up for that event, sign up early. And hopefully for those of you who are out of town listening, hopefully you'll fly into this event and be able to do that this year. We would love to see all of you in Atlanta. And last but not least, I would like to thank our current president, Brent Clinkscale, for his service to this organization. I think that he's been outstanding. And just to want to reiterate a few things just to stress how far I think we have come as an organization. Brent is our first president from outside Atlanta, from outside the state of Georgia. And I think that Brent has done a tremendous job with outreach to not only to South Carolina, where he's very involved in the Bar Association there, but to practitioners throughout the world, bringing them to our events and hosting events. Our membership has grown during the pandemic, and that's a testament to his leadership and also to Andy Tuck before him, who have done a fantastic job. I have big shoes to fill, figuratively and literally, because Brent used to be the quarterback for the Duke University football team. He doesn't tell you that very much, but I'm very excited about the future, and thank you very much. Look forward to seeing you at future events.
Thank you very much for inviting me. I would also like to invite you to the International Bar Association annual conference, which is taking place in the United States in Miami later this year. I mean, it promises to be an exciting event. We're coming back with in-person conferences, annual conferences. So it's taking place in your country. Please support it.